Good afternoon, participants, and welcome to those of you who have joined or are still joining for our Francis Taylor Building Planning Law update. I can see that the numbers are still going up quite fast, and so I'm just going to pause and wait until the numbers stop going up, but it's very nice to welcome I think it's 94 of you who are now here. But we'll just wait for a couple more moments. Well, we're up above the 100 mark now. Just while people are joining, I'll carry on with a few more words of welcome and just outlining the shape of the day. It's really lovely to have so many here. What is less lovely is not being able to see you. But we're now all very used to this way of working for webinars, but it's great that you're here. There's an awful lot going on in Wales at the moment, both legislatively and in terms of policy development. And we are going to give you what I think will be something of a whistle-stop tour of some of that this afternoon, with a planning and compulsory purchase associated emphasis to it. We're going to start in a few minutes when the numbers have stabilised with a talk from Craig Howell-Williams on the Strategic Development Plan Wales regulations, and SDPs and corporate joint committees. And I'm sure that many of you will already know Craig, his credentials as a planning and compulsory purchase and all things related QC, with plenty of experience in Wales, as is only fitting when you consider his name. Then I'm going to be giving an overview of the National Development Framework, which is now nearing its final stages, and that will start at about 2:30. And then just before 3, Annabel Graham-Paul will be talking about compulsory purchase in Wales and the new circular. She will be joining us straight from a virtual case management conference for a planning inquiry, as some of us are now getting quite familiar with those. Annabel, again, I'm sure many of you will know Annabel, both from working with her and from hearing her speak, especially on things Welsh. Annabel lives in Mid Wales and is very much involved in the local community there, as well as having a specialist planning and public law practice with a very strong Welsh emphasis. And finally, Dr. Charles Miners, who is just moving his screen around to show us his harp, because amongst many other accomplishments, Charles is a keen harpist, very appropriate for his particular links with Wales. Charles was for many years an eminent and much loved member of our chambers. We still regard him as part of our Chambers family, even though he is now working for the Law Commission, doing vital work to reform and properly codify Welsh planning law. And I think he's got aspirations over the other side of the border in that other place as well. But Charles will be able to update us on that work, which I think is reaching an advanced and exciting stage. So Charles will start his talk at around about 3:20, and then we aim to have some Q&A at 3:45. I'm afraid I'm going to have to bow out shortly after then because I have an immovable meeting starting at 4 o'clock. But Craig will take up the baton and will field any questions that we're going to deal with by Zoom. But please be putting up questions on the chat function as they occur to you, and we will do our best to be keeping up with those and making a selection of them, and maybe trying to cover the ones which most of you are interested in that closing session. We're now up to 125 participants. I'm not sure whether it's going to finish at that or not. I feel rather like somebody conducting a remote auction at the moment, but it has sat at 125 for a moment or two. So Craig, would you please start off with your talk on all things strategic development planning, please?
Yeah, thanks very much, Morag. If you could stop sharing your screen, I'll be able to share mine. That's it, and hopefully this this will work. Now, I'm very hopeful that my introductory page slide is visible, and I'll get a message if it's not, but I'm going to continue on the basis that everybody can see that slide, and I'm being told all good, so I can carry on. Well, thank you very much for attending this afternoon's webinar, and I'm first to go. I'm slightly nervous with Charles following me, bearing in mind the topic for my paper. I have told him that I'm envious of his ability to play the harp, which I had to give up at 8 years old, probably because I wasn't very good. And I'm also fearful that I'll get something wrong. But luckily, if I do, he'll be there to correct me. I'm going to talk about the consultation process being carried out at the moment on the forthcoming regulations for strategic development plans. And just by way of introduction, the Welsh Government, we know, is conducting this public consultation on the policy approach to establish regulations on the procedure for strategic development plans. Now, the regulations are going to have the thrilling title of the Town and Country Planning Strategic Development Plan Wales Regulations 2021. And they're going to establish the procedure for strategic development plans, which will be prepared across Wales by corporate joint committees. Now, please note the consultation has already begun, and it's going to close on the 4th of January. So if you need to make further representations, you haven't got long to do so. So before, I've just suddenly lost, please forgive me. I hope I'm back on, and I'll be told if I'm not. I'm going to look at the main features of what's proposed. Bear in mind that this is not the only consultation being carried out. There are associated consultations on establishing corporate joint committees. So the existing statutory framework, on the basis that some of us occasionally need reminding, governed by Part 6 of the Planning Compulsory Purchase Act 2004 and the Local Development Plan Wales Regulations 2005. They provide the procedure for the preparation and adoption of local development plans by local planning authorities. However, as you know, the Planning Wales Act 2015 amended that part of the 2004 Act with the introduction of strategic development plans. These were to be prepared at that time by strategic planning panels. 2 or more planning authorities could get together to do this, or Welsh ministers could direct that it would be done. So, for example, look at Section 60I of the 2004 Act, providing that strategic planning panels must prepare a development plan. Development panels, the development plans, forgive me, will be part of the statutory development plan. They will have to generally conform with the framework, and they must be done on the basis of sustainability appraisal. So what's happening now? Well, the Local Government and Elections Wales Bill provides changes to Part 6 of the 2004 Act, so that what are called corporate joint committees will prepare statutory development plans rather than local planning authorities. The bill confers power to the Welsh ministers to establish these committees by regulations. There's a consultation on the draft regulations for their establishments already underway, with the same time period, 12th of October to the 4th of January. The statutory development plan regulations are necessary for providing the procedural provisions which will supplement Part 6 of the Act, so that development plans are prepared by corporate joint committees rather than local planning authorities and given full effect in accordance with Welsh Government policy. Just a word or two about corporate joint committees. The bill has introduced provisions to create, via regulations, such committees. Similarly to the panels previously proposed, they're to be done by instigation of 2 or more principal councils or by direction of the Welsh ministers. And there are regulations along the way which will detail the specific functions of these bodies. They won't just be about planning and how they will be governed. Julie James has said that the corporate joint committees are being established in order, as she has said, to bring more coherence to and strip out some of the complexity of regional governance arrangements. There are going to be separate establishment regulations for 4 proposed corporate joint committees, although they're going to have generally applicable regulations of general principle. They're going to comprise a number of principal councils, and the principal council areas will form the area under the governance of the corporate joint committee. And they're going to be run by a committee of principal council members. So the consultation document explains more, including that the establishment regulations will set out that the 4 corporate joint committees will have responsibility for a number of things, including the following functions: preparing, monitoring, reviewing, and revising strategic development plans, developing a regional transport plan for implementing the Wales Transport Strategy. And then there's the economic well-being power, doing anything which is considered likely to promote or improve the economic well-being of the area. So these corporate joint committees are going to do more than planning per se. They're going to cover a wide range of functions. They're going to be busy. The context for the draft regulations for development plans, strategic development plans, is of course already with us in Chapter 10 of the Development Plans Manual. This indicates that the development plan process will largely mirror the local development plan process. However, as we know, but it's important to list them for reasons I'll come to, the strategic development plans are going to focus only on wider than local issues, and that covers a wide range of things: a vision, a strategy, the settlement hierarchy, and overall housing and employment requirements for each authority area, spatial areas to accommodate growth above a set threshold. They shall include a delivery trajectory aligned with infrastructure requirements and have a coordinated approach to environmental designations, including Green Belt. And they'll have a coordinated approach to energy, minerals, and waste. The Welsh Government will produce guidance relating to strategic development plan preparation with consultation, so there's more consultation to follow. Local development plans will remain a necessary part of the framework, but where they fall under a strategic development plan, they're going to be shorter and more focused on local issues. That's the aim. They're going to be adopted in around 2 years, and they're going to be called Local Development Plan Lights. It's quite a good, catchy phrase, but practice will let us know how successful that ambition is. And they're going to be new regulations are going to be made again with consultation. So what are the proposals? Well, the aim is that the regulations should broadly mirror the key stages and plan preparation requirements of the local development plan regulations on the basis that the process is already well understood. But 2 significant exceptions should be noted from the start. There's going to be no short form procedure, bearing in mind the strategic nature and complexity of these strategic development plans. And there are going to be no provisions for joint plans for similar reasons. The key difference, as is made clear in the consultation document, between a local development plan and a strategic development plan is one of scale. And this principle apparently is going to be reflected in the regulations. So looking through the 6 stages, I think, and going through them at a fairly whistle-stop speed. First, the community involvement scheme. The joint committees will have to engage with communities on the content of what's called a community involvement scheme. There will also be a plan preparation timetable. Collectively, they're going to be called the development agreement. Joint committees will not be able to begin formal preparation of the plan until the development agreement is not only agreed by the joint committee, but also approved by the Welsh ministers. The development agreement is going to set out the timescales for each stage of the plan process and how representations are going to be published and considered. The development plan is going to be prepared and adopted within 4 years. That's similar to the local development plan process. There's going to be a 2-stage process, the preferred strategy and the deposit plan before submission strategy. So far as the pre-deposit engagement stage is concerned, the regulations are going to will specify that there has to be a call for strategic locations and sites. Now that has to be undertaken before the joint committee can formally consult on its preferred strategy. So already there's going to be a significant amount of work which needs to be done even before consultation on the preferred strategy. The regulations will specify as well that the joint committees must engage with specific and general consultees on the range of strategies and options before finalising and consulting on a preferred strategy. Stage 3, the preferred strategy. Again, you'll see an echo of the local development plan process here. There's going to be a consultation for a minimum of 6 weeks at this stage. The regulations will specify that it must contain a preferred spatial strategy, must contain options, proposals, and implications, with earlier alternatives explicitly referred to. And just pausing there and keep in your mind the principle, the main difference highlighted between local development plans and strategic development plans being one of their scale, and consider that in the context of regulations which are intended broadly to mirror the local plan regulation process and also have similar timescales. So the regulation process is going to be based on particular principles, including the accessibility of documentation, minimum content, consideration of representations, and the publication of a consultation report with summaries of the main issues and an explanation of the extent to which they've been addressed. Stage 4, the deposit plan. Consultation for a minimum of 6 weeks. The regulations will specify there has to be a final strategy for all land uses, including strategic site allocations and policies and reasoned justifications. And there's going to be a proposals map or maps. There'll also have to be a supporting evidence base and SA and SEA reports to accompany the documents. The regulation process will, at this stage, again be based on principles similar to those in the previous stage. However, at the end, there's going to be the publication of an updated consultation report with summaries of the main issues again, and an explanation of how the joint committee considers that the issues should or shouldn't be addressed. And it's this document which will be considered during the examination process, along with the deposit plan. So the updated consultation report is required to do quite a lot, not only provide summaries of the main issues, but an explanation of what the Joint Committee has actually decided to do or decided not to do in relation to each of those issues. And the plan will be tested on the basis of those reasons. Stage 5, the submission of the deposit plan. The inspector will consider duly made representations in the normal way and determine whether or not the strategic development plan on deposit is sound. And again, reference here can be made to table 37 of the manual as updated for strategic development plans. So what will the inspector be looking at? Well, he'll be looking not only at the deposit plan, but the other documents that I've sought to highlight: the delivery agreement, the updated consultation report, the updated sustainability appraisal, and the habitats regulation reports, as well as the strategic locations and sites register. And at the end, there'll be the opportunity for adoption on the basis of the prepared adoption statement. Stage 6, monitoring, review and revision. Joint committees must publish and send an annual monitoring report to the Welsh Ministers by the 31st of October each year. These reports have to set out what policies have not been implemented, including remedial actions to address any deficiencies. And they must conclude as to whether a revision is required. They'll assess the extent to which the plan's strategy and key policies and sites and infrastructure requirements are being delivered. They'll also, according to the regulations, have to specify, the Joint Committee will have to decide, and it will have to review its development plan no longer than 4 years from adoption. But of course, it could consider it necessary to do something earlier, for example, in the light of framework changes, matter that Morag might touch upon. And joint committees must submit a review report to the Welsh Ministers within 6 months of commencing a review. There are, of course, other provisions. The regulations are going to contain provisions relating to the withdrawal of strategic development plans before submission, including reference to the Welsh Ministers within 7 days of the decision with planning reasons for the proposed withdrawal. The regulations will also set out procedures, publication and notification arrangements for the application of the Welsh Minister's powers of intervention, including reference to publication of reasons. So there's a lot going on, and just by way of some few comments, you've probably had some thoughts whilst I've been referring to the main elements of the proposed regulations. It's clear that the genuine intention to create a more strategic approach to planning in Wales is not itself a new idea. It's been around for some time, and some may think it's generally welcome. It's been provided for, of course, in the development manual. So we already have a feel of what the intention is. However, at the moment, the process is still at an early stage. Joint committees and development plan regulations are not going to come forward until some way into 2021. But of course, development plans, strategic development plans themselves are not going to be in place until some way hence. The policy intent, you may think, having heard my summary of the main provisions, appears sensible in many respects. It certainly has logic on the basis, as proclaimed, that broadly mirroring the local development plan process is sensible because people are already familiar with it. But remember the main difference that I highlighted at the beginning of this presentation: the nature and complexity of strategic development plans, the sheer range of issues, the geographic and the depth of the many topics that these documents will have to take into account, address in terms of policy. Are the timescales referred to adequate? We shall see what is made of the consultation responses. Is the devil in the detail? In other words, the broad provisions may mirror the local development plan process, but will there be differences in detail which are not yet evident through consultation? And lastly, a big uncertainty, you may think, the joint committees, a new beast in Welsh administration. Will they, bearing in mind their range of responsibilities and their functions as yet not set out in any detail, will they help or hinder the planning process, and in particular the process for strategic development plans? Well, thank you very much for listening. I'm going to hand you back to Morag now. Morag, thank you.
Thank you very much, Craig. There is an interesting question for you on the chat from John Davies, the former Chief Inspector of Welsh PINs. And he asks a characteristically pertinent question. So I'll leave you to cogitate on that, Craig, and turn now to my talk, which is on the national framework, the National Development Framework, or as it is now called, it's been christened by the government, Future Wales. And this is to be the national framework, the national plan to the year 2040. Right. There we go. It's what is it? Well, first of all, what it's not is a quick read. It runs to over 160 pages and comes with extensive accompanying documents. Some questions answered in there, some questions left unanswered. But the explanatory papers are actually quite helpful to enable us to understand at least some of the thinking. Legally speaking, it is the NDF is provided for through the Planning Wales Act and amendments made to the 2004 Act, and there must now be a plan to be known as the Development Framework for Wales. And so this is what it is, what it's in the throes of becoming. All sorts of detailed arrangements for public participation are set out in the legislation. And part of that, an important part of that, is laying the document before what is now renamed Senedd Cymru and used to be known as the National Assembly. And then once published, the plan is to be reviewed and revised if necessary. There's a duty to keep it under review. In the draft document, the commitment is to do that 5 yearly. But legally, the Welsh ministers may revise at any time, but if they do revise, then they must publish the revised version, and they have to go through all the same public participation and Senedd processes and hoops that they've been through in the first place.
Right, can I interrupt? I'm awfully sorry, but it may be the fault is at my end, but we can't see your slides, I don't think, or at least I can't. So something in the sharing has gone awry.
Right. Let me, right, I will just attempt to go back to the beginning again. Yes, this is curious. I now can't get this off my screen. Could I just ask Charles whether you can see it, or ask participants to say on the chat?
No, I can't see your slides.
Right, okay. I think, let me just try that. No, that's not going to work. There we are. This is the stuff of which Zoom nightmares are made. I do apologise. Try again.
You clicked on share screen.
I did, but what I hadn't done was get the thing up ready for it. So I've now, oh, rats. Yeah, I've now done that. We'll come back. Craig, while I'm doing this tedious business, I wonder whether you're able to answer John's question.
Yeah, up to a point. I can John's question, if I can be heard. John Davis has asked about whether there are any proposals for funding and staffing of joint committees, and the short answer is yes. The long answer, however, is to be found in sections 4 and 5 of the consultation document. The establishment regulations to which I've made reference will make provisions relating to the funding of these bodies, and they will require the Joint Committee to calculate a budget requirement for each financial year. In practice, the principal councils will require the committee to provide an indicative or provisional budget requirement to facilitate their own budget preparations. So it's quite I suspect, quite a complicated framework for determining budgets. So that's set out in section 4. So I refer you to that, John. And in the following section, there's also quite a detailed section on the staffing and workforce matters for joint committees. I have looked at this. It wasn't the focus for my presentation. The only point that you may feel is a shared one with me when you look at section 5 is that in terms of budget and in terms of staffing and in terms of the nature and functions that are for the joint committees, there's no denying that there's going to be some significant burden which is going to have to be shared and will be felt by principal councils and others when this new system comes into place. I think the one thing that's occurred to me when reading about joint committees and including these strategic development plans is actually the nature of the work, and just a slight concern that it is properly contemplated, the cost and resource implications for bringing them in. Morag, you're back with screen share on, so good, I'll let you back.
Thank you very much indeed, Craig. And my apologies to those of you who were missing the slides. These will be circulated afterwards. And I was just going through the statutory framework for the NDF, fairly briefly. Oops, there we go. And the role of Senedd in reviewing both the current initial NDF and any future reviews. Very importantly, the Planning Wales Act amended Section 34 of the 2004 Planning and Compulsory Purchase Act, such that the NDF, when it is published, will be part of the development plan. And then it also provides that there is a duty to have regard to the NDF when preparing the SDP and the LDPs for Wales. And we'll return to that because it is something of a theme within the NDF draft document. Where are we up to now? Well, in September, the Minister laid the document before Senedd for 60 days scrutiny. So that has now finished. They looked at the document and a schedule of changes, and there's a very helpful thing called a working version, which is an integrated version of the consultation draft and the schedule of changes. And as we've seen from the legislative framework, the government is bound to take into account of what comes out of this chamber in Senedd before finally publishing, which is due to take place in February. Turning then now briefly to the content of the document, there are a number of themes. So it's much more like the new look PPW rather than the old look PPW in terms of how it operates. And it is, of course, not the same as PPW, but it is to some extent a thematic document, and it is also very much a future generations document. For example, they've done integrated impact assessment, taking in both the statutory responsibilities under the SEA directive and regulations, and also under the habitat regulations. And so the themes, which we're now all very familiar with, the multicoloured future generations themes, are threaded through the document. Interestingly, dealing with habitats regs mitigation in particular, it is stated, and this obviously accords with the legislation, that the NDF and the work done on it is a strong guide at the lower tier plan stage. And it also says that at those lower tiers of plans, SDFs, SDPs and LDPs, that the relevant bodies must be able to conclude that there will be no adverse effects on the designated sites under the directive and regulations. And so that is interesting. It may be loose drafting, or it may actually signal that the approach being taken by the NDF precludes IROP justifications, so reasons of overriding public importance, which certainly legally is a rare but possible route to derogating from the habitats regs protection, and is something which at plan stage is sometimes contemplated, but apparently the NDF precludes that. As I say, it may be loose language, but that's certainly what it is suggesting. Other themes, we'll see a diagram in a minute about how the NDF is seen as an influential document in terms of framing government policy generally, and conversely in terms of, as it were, receiving and giving effect to Welsh Government policy. And we see the theme of placemaking emerging very strongly here, as it does in PPW. This is one of these organogram things, which places the NDF at the centre, and then we can see radiating inwards and outwards all of these other various plans, functions and pieces of legislation. So I include that there as a visual presentation for those of you who like such things. More tiers. Well, in certainly in England, with our COVID restriction approach that the Whitehall government is taking, we are fed up to the back teeth with tiers. But another theme of the NDF is the theme of development plan tiers. And so there is now a trinity of development plans. The national, the strategic, which we've heard about from Craig already, and the local or the new LDPs light. But those are all going to fall to be applied under section 38(6) of the 2004 Act of applications being decided in accordance with the development plan, unless other MAPCons indicate otherwise. The NDF Future Wales document, which is very discursive and does descend to a degree to policy, but policies that are pretty broadly worded, we may find that it's a bit of a motherhood and apple pie type document when we come to try and start thinking seriously about it under section 38(6). I've already pointed to the future generations role and relationship within the document, a bit of a chestnut with regard to future generations and planning, which many of us in this webinar, I suspect, have grappled with, is the familiar planning notion of balancing and of benefits and disbenefits, which I think we as planners perhaps find more palatable and easier to grasp than perhaps has been the case with some of the work that's been done on future generations and leading on that. There is, I notice, an acknowledgement of the need for balanced decisions and for sometimes difficult decision making within the NDF. But the theme of looking for wins across all the future generations topics continues in this document as well. It is very general when it does get round to spatial policy, as we'll see later on. It is at a level of high generality. And PPW's role is reaffirmed, but on the basis of being applied appropriately at each tier of the development plan. And I just pose the question, and maybe there'll be some thoughts in the chat about whether or not this is brave enough to be effective. I do remember asking Neil Hemmington at a presentation that he gave, oh goodness, pre-COVID, sometime pre-COVID, about how spatial the government were going to propose to be with the NDF, particularly with the green energy agenda. And I got the impression that we would expect, we should be led to expect a fairly non-spatial document, which certainly is largely what we have got here. That's how the document is organised, which is pretty self-explanatory there. And this talk looks at some things in a pretty high-level way, and others I've inevitably had to leave out or deal with very cursorily indeed. But turning now to the spatial strategy, it's urban focused and public led, and I know Annabel is going to be working through some of the implications of public led. The general message which we've been getting from the revocation of the 5-year supply duty within the housing TAN, and with the pattern of call-ins and call-in decisions is very much coming through this document. Focus on existing urban areas, speaking about greenfield development in unflattering terms. It's described as sprawling. A general theme of small is beautiful. Lots about being green and interconnected and placemaking, all very understandable stuff. But certainly some emphases which we'll come on to see a little later as well, on wanting to get away from what it sees as the domination of development by a few main players, and to open that out into smaller and different kinds of deliverers. There is the spatial strategy, as it were, at a glance, and that is described in one of the supplementary accompanying documents as deliberately not very geographical, purposely not a geographically accurate map. So it's akin to what those of us who are ancient enough to remember structure plans will recognise as being a kind of structure plan key diagram, except of course this is for a whole nation rather than just for one county borough. It's got growth areas there broadly indicated, and the detailed outworkings of those, we're told in the supporting document, are to be worked out in SDPs and LDPs. There is a very strong emphasis, again, unsurprisingly, in view of statements that the Minister has made, a very strong emphasis on more affordable housing. There are some numbers in the document, but these are policy off figures. So these are housing need figures to inform the 3 tiers of plans, but they are very firmly not housing requirements. And getting on for, I suppose, I'm not very good at fractions, but I think if you add 2/3 in the southeast and 1/5 in the southwest, you're getting on for 3/4 in the south, the rest in the northwest. And the split between market and affordable that the document is aiming for is 50-50. There is a national natural resources map. This is presumably, at least in part, in fulfilment of one of the duties in the Environment Wales Act. And that is interesting. It shows us lots of things that we probably already knew, but it is using the language of ecosystem services which again is language coming through from the Environment Wales Act. Then a few topics. I've not gone for every policy topic, but some of the main ones, and I've taken their flooding and biodiversity together, which I honestly chose to put together before it occurred to me that a Noah's Ark cartoon would neatly encapsulate both. But there is to be a local authority strategic approach to selecting development areas and a continuation of the policy that new greenfield development should not be enabled by the development of new flood risk management infrastructure. So this is allied very much to the urban focus, and indeed in terms of ecology, looking for biodiversity net benefit, and again, interestingly, a strategic approach to ecological networks, the recognition, identification of those and safeguarding of them, again, clearly in line with the Environment Act. Transport. We range through from the international to the extremely local. Investment in many forms, or all forms of active travel and public transport and e-charging points. The sustainable transport hierarchy that we're now familiar with from PPW is reaffirmed. And I noted one thing, which I'm going to have to look out for very carefully in future, which is a default national speed limit of 20 mph on restricted roads. So I can't hurry along on my way to inquiries, site visits and such. Tackling congestion. I've got a particular interest in this because, as many of you will know, I'm still bearing the scars, as it were, from having conducted the M4 inquiry on behalf of the government, and having spent a long time dealing in evidence with causes and potential cures for congestion. The policy as set out in this document is a pinch point programme of enhancements for North Wales, and in South East Wales we're still waiting on the Transport Commission, who are going to answer the leftover questions to do with the M4. So I wish them pob luck with that. A map there, another strategic map of corridors and metro developments. Interestingly, the increased capacity and resilience there apparently confined to a sort of L shape running between North and Mid Wales. Commitment to investment in and support, or at least supporting in development of digital, and a national forest, which gave me the excuse to put a seasonal tree on one of the slides. This is an interesting idea of safeguarding areas for a future forest. And again, we see these cross-cutting themes. It's seen in terms of economy, climate change, and flood risk management. Wind energy and heat networks and energy policy. There is a presumption in favour of large-scale wind and repowering of, as it were, generations 1 and 2 of large-scale renewables developments, but not in national parks or AONBs. And the relevant map has, we've gone into the regional map. Sorry about that. They're effectively the TAN approach of strategic site areas is forward, basically.
And then for smaller renewals, there is a
criteria-based policy, and the thresholds are there set out in the MDF. Policy 19 is an important one, which is why I've included it there for your convenience. Time's not going to permit me to go through that, but it sets out what we looked at on the national plan in words effectively there. And then just in concluding, the regions at a glance, Wales has been divided up for these purposes into regions. We're starting here with the north, and you will see there a green belt east of Wrexham and southeast of Deeside along the border there, and that is, as it were, edging or blocking a national growth area, which is running to the west of it, and then connecting into a regional growth area. So there, with the different colours, with the purple stripes as opposed to the green blobs, we've got there the phasing of the tiered approach between national areas and regional areas. It remains to be seen actually in practice how the differences between that will work out. I suspect that that is work which is going to be done by the SDP teams. Then Mid Wales, there's really a focus on looking at the existing centres of growth there and having a bit more of it. Basically, in a nutshell, with, as you will see, quite an emphasis there on those pre-assessed areas for wind energy, so the equivalents of the SSAs. In the southwest, more wind power there, and a national growth area around Neath, Swansea and Llanelli, perhaps unsurprisingly, and other regional growth spots further west, together with the ports, which there's a whole theme or section on international transport connectivity. And then Southeast Wales, a very large new green belt, about which I've received one question already, about the soundness of that. I am certainly well aware that there was a feeling that this green belt, as it were, came from nowhere in particular. The justifications for it in the accompanying documents don't anywhere mention the familiar approach to green belt of there needing to be exceptional circumstances in order to establish a new green belt. Obviously, we've seen there's also one in North Wales. It's apparently much more to do with driving development into the urban areas in the face of what's seen as land value rises since the removal of the tolls on the bridge in the south, and by reference to the proximity to the border in the north. The idea is that it will promote use of PDL and transport infrastructure investment. I must raise the question, which occurs in my own mind, which is as to the robustness of the economic model for this. I suspect that that is something which is concerning other people too. There is a difficulty because under the tiered system and under Section 62, which requires regard to be had to the NDF, it is very difficult to see what scope there will be for the relevant SDP to come forward with anything other than that, save for maybe some tinkering around the edges, given that it is diagrammatic. I know that that's a matter of concern to a number of people, and certainly I've received a question in the chat about that already. So there we are. There is lots to think about, lots to debate. And as soon as this is published, I suspect that focus is very much going to turn to the SDPs, of course, assuming that nobody has the appetite for any form of legal challenge to this document. We're slightly running behind programme because of the technical difficulties, but we have taken questions, so I draw some comfort from that. I've seen that Annabel's now joined us, and so Annabel, if you could share your screen with your slides, we'll go straight on to your talk, please.
Thank you very much, Morag. I will attempt the screen share. I'm sorry, I don't know what technical difficulties have occurred, but they usually happen with me. It says you cannot start screen share while the other participant is sharing. So I think I'll just have to wait a minute.
I've stopped sharing now.
Brilliant. Try again.
And the technical difficulties were due to me last time, so you weren't.
There, has that worked? Hooray, good. Okay, we're in business. So, well, good afternoon, everyone. And it's very nice to be with you all virtually for our Planning Wales event. So I'm speaking about compulsory purchase and the new circular. And the reason that I felt it was important that we touched upon compulsory purchase in the context of our planning seminar this year was because compulsory purchase, well, first of all, there's a lot going on in Wales with it at the moment, but secondly, it's very much being emphasised by the Senedd and the Welsh Government that it is critical to the delivery of good planning. And Julie James spoke at the inaugural Wales Compulsory Purchase Association annual conference in October. She gave the keynote speech. And it was just a day or two before the new circular was published. And she made the point that as we're coming out of the pandemic, you can really see the difference between whether you live in a decent house, in a decent place, with a good community spirit. And so she was very much focused on putting the principle of placemaking at the heart of the planning system in Wales, and said that compulsory purchase was fundamental to that. We must do the right thing by our communities for future generations and think more about placemaking, and with that use compulsory purchase powers to bring land forward to create good communities, and in particular good town centres, which of course have suffered perhaps disproportionately or particularly badly as a result of lack of footfall during the pandemic. So setting that sort of broader context to compulsory purchase in Wales at the moment, just a little recap as to where we are with compulsory purchase in terms of competence and powers. The Wales Act 2017 moved Wales towards a reserved powers model so that all subjects can be legislated on unless they are expressly reserved to Westminster. This was adopted following the recommendations of the Silk Commission. The consequence for compulsory purchase is that before this, it was what was called a silent subject. So the Senedd could legislate in relation to compulsory purchase powers, but only if they fairly and realistically related to another subject, for example, highways. Originally, it was proposed that compulsory purchase of land would be reserved, but following changes in the House of Lords, only land compensation is reserved to Westminster, and CPO powers and procedures are now within the competence of the Senedd. So that is the position that we've ended up with. So we've got a split between compulsory purchase and compensation, but it means that the Senedd can now enact primary legislation in relation to compulsory purchase in its totality, which they weren't able to do previously. So armed with those new powers, in June 2019, the Economy, Infrastructure and Skills Committee made certain recommendations as to how Wales wanted to forge its own path with regard to compulsory purchase. And there were a number of responses to a call for evidence. The report focused strongly on the importance of updating the circular. The previous circular stemmed from 2004, so it was of quite some date. There was also a concern that there had been, perhaps since the abolition of the Welsh Development Agency in 2006 and other bodies, perhaps a little bit of a lack of expertise amongst local authorities in using compulsory purchase. A lot of perhaps skills hadn't been developed, and there was a lack of confidence in using compulsory purchase powers. So there was a strong emphasis on providing a clear steer to local authorities on the benefits of using the CPO process and giving people the confidence and the knowledge and the skills in order to be able to take up CPOs and run with them. So other recommendations were the establishment of a pre-checking service of CPOs by the Welsh Government. So on an informal basis, authorities can submit orders to be checked in advance so that any technical errors can be ironed out before they are actually submitted. There were also recommendations about encouraging alternative dispute resolution, and I think there's been liaising with RICS going on about that, and also the developing of a shared resource expertise. So very much focused on how the expertise that formerly resided in bodies like the Welsh Development Agency could be revised and made available to public bodies so they can share resources and experience, and again, just all part of building confidence and knowledge in using compulsory purchase powers. So that's some of the background to what it was felt was needed to be done to address the perhaps lack of uptake in making compulsory purchase orders in order to bring forward land. And a response from the Welsh Government was that they would update the circular and also create a Cpo Manual. They were also looking at options for technical review and then looking at the remit of the public sector land division with the potential to use the regional joint structures under the Local Government and Election Wales Bill, which is currently before the Senedd. So they were looking at expanding the remit of the land division. So that's how we got there. And then, as I've said, the new circular that has resulted was published this October. In terms of the aim of it, as I've said, it's very much designed to encourage the use of CPO powers and to build confidence and knowledge. So the style is discursive and informative. It's quite long. It's rather similar to a practitioner text, but in terms of length, it's there in that length because it is there to inform about the powers rather than just simply saying this is the policy or that or do that or do that. So it's designed to assist local authorities to have greater confidence. It includes a number of really helpful checklists and toolkits. There are examples of best practice in it, for example, in terms of the erection and maintenance of site notices, list of the documentation to be submitted with a CPO, that kind of thing. There is a template model claim form for compensation, and there's also guidance on compulsory purchase enabling powers and procedure for making a CPO, process charts with steps and timescales for processing and determining of a non-ministerial CPO. So all these kind of practical things that are particularly useful for those who haven't had that much experience previously in compulsory purchase. So I've got it. If you want to, the reason I can't go through it in detail is this is it in this big file here. And so if you get the idea, it is quite a weighty document, but it's a very useful reference kit to have by your desk if you are working compulsory purchase, and you can use it almost, as I say, like a practitioner textbook. There's also, in terms of updating, a section on compulsory purchase and the wellbeing goals. It doesn't pepper the wellbeing goals all through the circular in the same way that PPW does, but it sets out very clearly how compulsory purchase decisions need to be made with the wellbeing goals in mind, and the ways of working being applied there as well. So that's a quick run through the circular. As I say, it's, it would be pointless me taking you through each and every section of it, because it goes through the whole of the process, but it's imperative to have as a reference toolkit. It's also actually probably quite useful in England as well, because at the moment, you know, the enabling primary legislation is still the same, although I'll come on to how that might change. And so a lot of the guidance in here is also going to be useful in relation to the law in England too. So turning then to other developments that have followed on from the committee report of the Economy and Skills Committee. Obviously with Morag's talked on the new NDF policies, but there's a particular one that I would draw your attention to in relation to compulsory purchase, and that's policy 3, which deals with supporting urban growth and regeneration. And this provides that the Welsh Government will play an active enabling role to support the delivery of urban growth and regeneration. The Welsh Government will assemble land, invest in infrastructure and prepare sites for development. We will work with local authorities and other public sector bodies to unlock the potential of their land and support them to take an increased development role. So very much setting out that the Welsh Government will assemble land and will work with local authorities in order to unlock the potential of their land. So looking at the use of compulsory purchase there. And then it goes on to say that the public sector must show leadership and apply placemaking principles to support growth and regeneration for the benefit of communities across Wales. So it's very much, I think, as Julie James actually said again in that keynote speech at the CPA conference, we want the public sector to show the leadership to the private sector as to how to build the communities that we want, take public land and show people how a real community can be built. So that leadership from the public sector is there embedded in the NDF. The next point, second bullet on the slide, is about codification. Charles is going to come on and talk about codification of planning law, but that is of course the pilot codification that is going on, and the Legislation Wales Act 2019 provides that there will be a programme of consolidation and codification of all of the law in Wales, and compulsory purchase codification, although outside Charles's work at the moment, will be envisaged to come forward in due course. The next development to keep an eye on is Lord Thomas's report, Justice in Wales for the People of Wales, which was published in 2019. And this looked at the potential for devolution of justice, because of course, at the moment, we're still in a single jurisdiction for the purposes of justice and policing. That report firmly recommended that justice and policing should be devolved to the Senedd. Obviously, with the onset of COVID, progress in that debate is has been a little bit slowed, and we'll have to see how that goes. But the existing devolution settlement does still allow Wales to create its own system of tribunals, and we'll have to see how that might, coming forward, impact on compulsory purchase. At the moment, compensation is of course remaining to be determined through the Upper Tribunal Lands Chamber, but there may be scope for Welsh tribunals to be involved in determining disputes to do with compulsory purchase, and that should be the position in terms of remedies, because if it's under future Welsh legislation. Finally, the Cpo Manual, which I think was intended to accompany the new circular, hasn't been published yet, and I'm perhaps somebody who's anyone who's watching from Welsh Government might be able to update us more than I can as to when it is going to be published. But all I've heard is, or read, is later this year, although we are obviously very nearly at the end of this year. So watch this space. Hopefully that will be coming out soon. And again, that will provide another reference and toolkit for local authorities and others to use to gain confidence, knowledge and skills in compulsory purchase. And then finally, the sort of big thing that's going on at the moment and important for all participants to engage with is there is current consultation going on whole-scale reforms to primary legislation and secondary legislation in terms of compulsory purchase. And so this is taking up the point about updating and tweaking the process to make it more efficient, more user-friendly. And the deadline for responses on that consultation is the 19th of January next year. So if anybody is feeling a little bit bored over the Christmas holiday period, that's something that you can get on with in terms of reading that consultation document and responding. But in summary, the proposals to amend primary legislation are there to modernise the processes, particularly a lot about electronic communication, service, notification, site visits, that kind of thing, to bring it up to date with new technology, and also secondary legislation, particularly to do with inquiries and streamlining the process and the procedures. So I've just put here a quick summary, headline summary of what the proposals are, so that if they are of interest to you, you can go and look at the consultation document and respond to it. So in terms of primary legislation reform, there are proposed changes to the site notice and publicity requirements, service of notice and documents, greater flexibility in considering remaining objectors other than by way of a public inquiry, so being able to deal with them via hearing or written reps, and allowing acquiring authorities to confirm their CPOs in some circumstances. Then in terms of changes to secondary legislation, there are changes proposed to the public inquiry procedure, as I've mentioned, making use of electronic communications, telephone and video pre-inquiry meetings, which are already going on in terms of planning inquiries, but the compulsory purchase legislation has really very sort of set procedures in it. So it's to basically bring those up to date and streamline them and make them more flexible. New timescales for statements of cases, timescales for inspectors conducting site visits, and changes to the notification of inquiries and publicity and the depositing of CPO documents. So it's all very sensible and practical stuff, which hopefully will add to the toolkit that's already there with the new circular, the Cpo Manual, a pre-checking service, which I don't think is coming quite yet, but will come in, to just make compulsory purchase a little bit less impenetrable and a bit easier for people to get on with in order to deliver on the placemaking objectives. So that's been a run through where we are, but as I say, the important points are: get the circular printed out, because it is quite long, and have it there as a useful reference tool. Be confident in using compulsory purchase if you're a local authority or another public authority that has those powers, and see it as part and parcel of the toolkit for bringing forward good placemaking, particularly in terms of town centres. And finally then respond to the consultation document. So I'm happy to take any questions now or at the end. I'm not sure how we are doing it, Morag.
Okay, thank you very much indeed, Annabel. I think we'll try and save them up to the end and move on to Charles's talk. If you've got questions for Annabel, do be putting them up on the chat. I think there are one or two up there already. I've been dealing with some questions offline, and if there's time at the end, we'll maybe have some of them under discussion as well, in case they're of wider interest. But Charles, are you now able to share your screen and to join us? I'll mute and invite Annabel to do the same. That's looking good, Charles. Thank you. Charles, we're seeing your paper, but we're not hearing you. Well, I'm not anyway.
Unmute. Try, can you now hear me?
Yes.
Right. Can you now see? Can you see and hear me and see my paper?
Yes.
Right. Whether you want to is a different question. But there we are.
Fine.
Right.
Thank you.
Okay. Shmai Paub Prananda. I'm doing my sort of annual party piece of an update on planning law in Wales, where we've got to. Since the last FTB planning law seminar, we have moved on a little bit because the First Minister, for whom I have the greatest respect, because he's got power and I haven't, he says in the Senedd, in the debate on the legislative programme in July, immediately before the summer recess, he said, in terms of primary legislation, the next government will be under a duty to have a programme for consolidation and codification of its legislation, work for which is underway in the historic environment and planning fields. And I can confirm that is indeed the case. Work is indeed underway. So we are now beginning to see that there is real hope that Wales will, hopefully before England, actually have a decent system of planning legislation in the foreseeable future. Just to remind you how we got here, Consolidation of Planning Law is the first codification of exercise since the Law Commission report on the form and accessibility of law in Wales back in 2015. It's been proposed by the Welsh Government for some while. The Law Commission was invited to produce a scoping paper and a consultation paper on possible changes, because normally it's worth remembering that consolidation means simply bringing together all the existing law, but not changing a thing. So consolidation, if, for example, you have planning inquiry commissions in the Planning Act, nobody's ever held a planning inquiry commission, nobody's ever going to have one, nobody knows what they are, nobody's going to use them. But if you can simply consolidate the law, you will roll forward into the next Planning Act the same unused provisions about planning inquiry commissions that nobody needs. So one of the things we're trying to do is to make technical suggestions for technical improvements to get rid of a lot of the rubbish that nobody uses and to simplify it and to bring it into line with what actually happens in the real world. And so it's both consolidation and simplification. And we say we had a consultation paper in 2017. We produced a final report laid before Parliament in Westminster and the Welsh Assembly, as it was then, in Cardiff, down in the Bay, in December 2018. And there it is, complete with the dragon. The Welsh Government issued an interim response to that final report in May 2019. And Julie James, who seems to get a place in every talk this afternoon, the Minister, said she supported the Law Commission's view that there is a particular need for a code bringing together the legislation relating to land use planning. Having the legislation in a single place will assist in addressing the dispersed nature of the current legislative framework, and this in itself will make the law more accessible to stakeholders. And crucially, this view is shared by the Counsel General. So that means that the Planning Minister, who is, of course, herself a former local authority solicitor and knows all about planning law, and the Counsel General, who's in charge of the government's legal programme are both in favour. And she went on to say, I welcome the Law Commission's view that the scope of the initial consolidation should include all planning-related primary legislation relating to the planning and management of development, infrastructure and other improvements, outdoor advertising, trees, public sector-led improvements, and supplementary and miscellaneous provisions, the odds and sods that we never normally use, like purchase notices and revocation and all those other bits and pieces that you never look at. What is going to be replaced? She said the initial exercise should result in the replacement of the main pieces of primary legislation underpinning the system of Wales, in particular the 1990 Act, the 2004 Act, as they apply in Wales, and that of course gets rid of all the bits that apply only in England, and the acts that amend those two, notably the ones in 1991, 2008 and 2015. So there's an awful lot of legislation out there. Some of it amends the 1990 Act, some of it is alongside it and freestanding. But all of that will all be swept into just one piece of legislation. The obvious question, though, is not could it happen, might it happen, wouldn't that be a nice idea, is will it happen? Well, in 2019, in October 2019, there was a paper called The Future of Welsh Law, which Annabel just referred to as well, on classification, consolidation, codification of Welsh law. A major, and that looked at all the possible areas of law applying in Wales, particularly statute law, and said that they would be consolidated and codified in topic areas. She mentioned compulsory purchase. That's probably somewhere down the list, but it's one of the areas. But that consultation paper, which was issued by the Consul General, pointed out that a major project is underway to modernise and consolidate the law on planning. This brings together policy and legal expertise from the Welsh Government and the Law Commission, working closely with the Office of Legislative Counsel. The Office of Legislative Counsel, the people who actually draft acts of the Senedd. And he went on to say the Welsh Government is also working on consolidating the law in the historic environment, though this doesn't involve the Law Commission. And most recently, the Welsh Government has published last month in November its detailed response to the Law Commission final report, in which it said the Legislation Wales Act places a duty on the Welsh Ministers and Council General to bring forward a programme to improve accessibility of Welsh law. As the content of the first formal programme will be a matter for the government of the next Senedd term, this response cannot provide a commitment to the inclusion of a planning consolidation bill in that programme. So in other words, I can't at this stage guarantee what's going to happen in the next term. That depends not least on the outcome of the election in May 21. However, the Consul General and I, that's the Planning Minister and I, the Consul General and I, the Planning Minister, have advised officials to continue the preparation and drafting of the consolidation bill on the basis that it will form an important part of this programme for introduction to the Senedd next term. So what that's saying is that the current position, and this is only about November the 10th, I think it was, so less than a month ago, is that preparation and drafting of the consolidation bill is to continue, and I can report that it is indeed continuing and it is well advanced. Of course, that is subject to not only the results of the Senedd elections in May 2021, but also pressures from Brexit, global pandemics that may occur, and any other various hazards. So that doesn't mean it will happen. And one's got to remember, I mean, I think a lot of people, for example, thought the M4 around Newport was going to happen. A lot of people thought all sorts of things were going to happen. That merely because something is well advanced doesn't mean it will. But as far as one can be certain of anything in this life, then there is a reasonable chance that it's going ahead. So what happened to the various recommendations made by the Law Commission for technical reforms to go in the Consolidation Bill. The Law Commission made 192 recommendations. 61% were accepted, just without further ado. 25% were accepted in principle. 8% were rejected. And 6% were taken on board as supporting evidence in future review of the law. And we'll come to some of each of those in a few minutes. What I've done is to go through the principal recommendations, not all 192 of them, because I know you want to get to bed tonight, and to look at what happened to the principal ones. The first group were the introductory provisions. We want to start the Act with some sort of, or start each bit of the Act, remains to see exactly how we'll fit it in, with a look at the duties that actually apply to all planning decisions. At the moment, there are a lot of planning decisions where you've got to have regard to the development plan development plan, not development. You've got to have regard to the development plan and all other material considerations. That applies to obviously deciding applications and appeals and enforcement appeals and so on, but it doesn't apply to a lot of other tasks under the Planning Act. And so we want, as far as we can, to bring that in as a general principle, to have regard to the development plan and what will in future be all other relevant considerations. I don't think anybody nowadays uses the word material, except planning lawyers. And amongst the relevant considerations will explicitly include the Welsh language impact of any decision and the Welsh government planning policies. Anybody who knows anything about planning knows that in real life, that the government planning policies are just as important as the development plan. The duty has been accepted in principle, and the relevant considerations has also been accepted. But we said in the report that we thought there wasn't a need for the Town and Country Planning Act 1990 to explicitly refer to the sustainable development duty under the Wellbeing Act. And the reason we said that was simply because there are lots of acts of Parliament like biodiversity, national parks, areas of outstanding natural beauty, and disability, and all sorts of other acts that provide general statutory duties. You must have regard to them. And we thought it was a bit odd to fish out the Wellbeing Act in particular. However, the Welsh Government said that they thought actually the Wellbeing Act was so relevant to planning and so central to planning that they thought that even though it would be duplication with the Wellbeing Act itself, we ought to include a direct reference to the Wellbeing Act. And so that will remain in the new bill. So our recommendation was based on sort of tidy-mindedness. The Welsh Government slapped us down and said they didn't accept that. Fair enough. The one or two basic sort of nuts and bolts things. Local planning authority becomes just the planning authority, as in Scotland, because there isn't any other kind of planning authority. The planning authority will in future always be the local authority or the national park authority where there is one. In other words, it won't be the New Town Development Corporation, the Enterprise Zone Authority, the Urban Development Corporation, the Housing Action Trust. All those will be dropped as planning authorities because they almost never are in practice anyway, but that will simplify the legislation a great deal. Persons appointed by the Welsh ministers simply become inspectors, which is what everybody in real life calls them anyway. And that last one about the inspectors is of course subject to the setting up of the new independent planning inspectorate for Wales, and that of course may affect that. The development plan will be include all the provisions in the 2004 Act really will be reunited again with the rest of planning legislation as they were pre-2004, and they will all be brought in. But of course, they will include the amendments to the 2004 Act made by the Planning Wales Act in 2015 in relation to the national, the NDF, and the Local Government and Elections Wales Act 2021, which Craig has just been talking about. So those changes obviously will all be included. And that's obviously been accepted. The definition of development will be slightly tidied up. Some of the sort of slightly more complicated bits will be trying to simplify it and just make it easier to understand. No substantive changes, but hopefully easier to get your head around the definition of development. And that is important because it's the definition of development is one of the most frequently referred to sections of the Act. Permission won't in future be able to be granted by an enterprise zone scheme or a simplified planning zone scheme. That's an example of a provision that nobody ever used, so we'll just get rid of it, and that's been accepted. And the provisions as to certificates of lawfulness, which are currently with all the enforcement bits of the Act, will in future be alongside the bits saying what is development and when do I need planning permission, because you should be able to apply for a certificate of lawfulness with no question of enforcement or being on the naughty step. You simply apply for a certificate just to find out whether you need permission or whether you don't. And those have all been accepted. The first sort of major controversial one is in relation to applications. We suggested in the consultation paper, we suggested that there was no need for outline planning applications because the reality is an outline planning permission subject to approval of details on the one hand, and a detailed planning permission subject to conditions as to things to be approved on the other, were for all practical purposes identical, and there seemed to be no particular difference between them. When that was in our consultation paper, when we went out to consultation, there was a slightly equivocal response. Some people thought it was a good idea, some people thought it wasn't. And so we, on balance, suggested we would drop that proposal. The Welsh Government, in effect, said, well, you may not have convinced all the consultees, but you convinced us. And so we do think that outline planning applications should be scrapped. And there will in future, therefore, simply be a single way of getting planning permission, which will be planning permission, but of course, in many cases, subject to all sorts of things needing to be approved at the detail stage. But there won't be a separate actual animal called outline planning permission. How that will be incorporated remains to be seen, so will need to be considered further. We suggested that the requirement in section 327A that authorities had to reject applications didn't quite comply with all the details. We said that should be made discretionary. Welsh Government said no, it should be continue to be mandatory as at present. We suggested dropping the prohibition against twin tracking, so twin tracking appeals, and that's been agreed. We suggested that bringing together conditions and limitations. Nobody except extremely bright planning lawyers knows the difference between a condition and a limitation, and we thought it served no useful purpose, and so scrap that. And we also thought it was helpful to introduce into on the face of the Act the Newbury test for conditions. You can only have a condition when it's relevant and relevant to the development, relevant to planning, and so on. That should be in the Act, not just in a case law. We thought you should be able to, the planning authority should be able to issue split decisions, so they can, if you apply to do A and B, the authority should have an explicit power to give you permission for A without, but reject B. There is some doubt as to whether that's possible. And we also thought they should, authority should have to provide reasons where they grant permission against officers' recommendation. That was a decision of the Supreme Court in a case in Dover in England, and that will be in the bill in future. And all those have been accepted. The provisions as to the application direct to the Welsh ministers, either for some larger developments, or where a local authority is non-performing, underperforming, they will be incorporated as they are. Planning inquiry commissions, as I mentioned earlier, will be dropped, and that's all been accepted. SIL and planning obligations to be included in the bill, they will almost certainly be those, I would guess, subject to some further review, because SIL and planning obligations are always under permanent review. You will know, those of you who follow what's going on across the border, sorry, let's go back. Those of you who follow what's going on across the border know that there is a new system of a planning levy being proposed in the white paper in England. Whether something similar will one day happen in Wales, who knows? I have no special knowledge on that. But for the moment, at least, we will certainly put SIL and planning obligations into the planning bill where they belong, not in a separate piece of legislation. The purpose of planning obligations, rather oddly, in Regulation 122 of the SIL regulations, that will be included in the bill, and planning authorities will be able to enter into planning obligations in respect of their own land or land owned by prospective purchasers, and that will make life slightly easier. And we will make the common sense thing that at the moment, in theory, all appeals are determined by the Welsh ministers, except where there's in one or two cases they go to inspectors. But we all know that in reality, all the appeals are done by inspectors, except the very few cases that go to the Welsh ministers, and that will be incorporated on the face of the Act. And lots of technical changes to enforcement, none of them remotely far-reaching. They have all been approved, or at least approved in principle. Criminal procedures to be more consistent, and various technical fine-tuning. There are I think about 30 recommendations about enforcement. There's only just a few of them there. Listed buildings, we suggested that it would be sensible to require a local authority to have a duty to have regard to the desirability of preserving and enhancing any historic asset, not just listed buildings or its settings. And we said they should be able to grant planning permission, not just listed building consent by heritage partnership agreements, but not make development orders to grant permitted development for listed buildings. And the grounds of planning appeals, as well as listed building consent appeals, should be able to include the claim that the building shouldn't be listed. And those were basically recommendations to bring the planning regime into line with the listed building consent regime. And we then went on to say that if you've done all those things, actually, you don't need listed building consent at all. You could just replace it with planning permission. Because once you've actually brought the planning regime into line with listed building consent, you actually need listed building consent or conservation area consent, and that works to listed buildings conservation areas would be a criminal offence, and you didn't need a special statutory regime. And all of those recommendations, the Welsh Government sort of said, well, in view of the controversy caused by those recommendations, and I know it did cause controversy, and a lot of people were very unhappy with those, the Welsh Government basically didn't reject them. They merely said it's too difficult for the moment. It's not suitable for a consolidation bill. We'll think about it, and we will put them to one side. In other words, we'll kick them into the long grass. So let's see what happens. We made various suggestions about advertising, and they're all relatively minor, but you can get a certificate of lawfulness for the display of advertisements, various definitions tightened up. The period for advertisement to become lawful will come after 10 years, not if it's been in place since 1974. Procedure to enable removal of unauthorised advertisements, not just hoardings, and an unlimited maximum fine for unauthorised advertisements. All of those have been accepted. Trees, we suggested that you've got to make TPAs in the interest of amenity, and we suggested that amenities should include age, rarity, biodiversity, and so on, not just appearance. That's been approved in principle. We suggested that tree preservation orders should be separated from woodland orders because they're slightly different. Rules tightened up on dead, dying, and dangerous trees, and the exemption for trees that are causing a nuisance should simply be dropped. That's been accepted. Certificate of lawfulness, we suggested, should be introduced for works to trees. That was rejected. Oh well, can't win them all. That you should be able to plant a replacement tree at or near the tree that was being removed, not just at the same site, because that's more practical. And there should be a single offence as for listed buildings, not one offence, not two different offences for causing death and causing other damage. And finally, that trees in conservation areas, the procedure should be greatly simplified. 215 notices, we suggested merge with the National Parks Act. That's all been accepted. But we also suggested you shouldn't be able to serve a 215 notice. The authority shouldn't be able to serve a 215 notice where the damage to the land is due to a third party. That was rejected. We suggested that there should be a new power to make regulation for the Welsh ministers to make regulations to deal with graffiti and fly posting rather than have them in the Act itself. That's been accepted in principle. We suggested doing away with lots of different kinds of other zones and areas. Enterprise zones, we said, should be scrapped. There are two kinds of enterprise zones. There are those under the 1980 Act and those under the Finance Act 2012. All the ones that currently exist are under the Finance Act. They will remain, but the old type of enterprise zones under the 1980 Act will be scrapped. Housing action trusts and rural development boards dropped because they're never used these days. We also suggested that new towns and urban development corporations should be dropped because they're never used, but that was rejected. They said that basically they might still need them. We suggested that all the provisions in Part 9 of the Act about the acquisition of land for planning purposes should be included in the bill. That means that as a result, that will enable us to do away with the 1990 Act in its entirety for Wales, and you'll just simply go, the 1990 Act will continue to operate in England, but you won't need it at all for Wales as a result of including Part 9. And Part 12 of the Planning Act, which is the bit that provides a special regime for making challenges in the High Court to decisions, is now almost entirely duplicated by standard judicial review and is therefore completely unnecessary. And that's been accepted in principle. It may need a bit of fine tuning to see how it works in detail. And then finally on odds and sods, the definitions of statutory undertakers, mining operations, dwellings, curtilage, agriculture are all being tightened up and clarified. And the rules as to costs of appeals to be in the bill. So a lot of detail, a lot of change, generally, as you see, accepted, but not universally. A few things rejected and a few things set aside and kicked into the long grass. So where do we go from here? Possible timetable is expected to be, or might be, or could be, historic environment goes first because it's shorter and will be a useful guinea pig. And that could go in the autumn of 2021, Royal Assent in 2022. Planning going in 22, Royal Assent in 23, consequential provisions bills alongside them. But as I say, they may be delayed or scrapped due to pressures on Senedd time or for any other reason. And the statutory instruments also need updating, the use classes order, the general regs, adverts, trees, and of course the GPDA. Hopefully they will be done not necessarily exactly at the same time, but around the same time. And it will be publicised through the usual sources. The encyclopedia is considering a Welsh volume, and legislation.co.uk is being updated and improved, especially for Wales. So hopefully it will be easier to find in future. So that's what's happening. Let's see where we've got to by this time next year. Diolch yn fawr iawn ac wrth gwrs dyma ni dau gorau yn nadolig hapus blwyddyn newydd ffrwythlon. Diolch.
Diolch yn fawr I ti, Charles, and also to everybody who is still following the webinar, and there's still lots of you. We have got time, very briefly, for a couple of questions, and if Craig will forgive me, I'll just try and deal very swiftly with my ones first, and then say goodbye and season's greetings to everybody. And there were some questions for Annabel as well. Just very quickly, I've had two really interesting questions, basically on the relationship of the NDF to other bits of the development plan. One was in the context of the requirement in two parts of Wales for there to be a green belt in SDPs, as opposed to support for there to be a green belt in certain other parts, or green belts in certain other parts of Wales. And one was a question about the Trasfynedd potential site for a small modular reactor, small modular reaction, I suspect there would be, a large modular reaction perhaps, in Snowdonia National Park. And very briefly, section 60, large B, capital B, which I mentioned on one of my early slides, is the procedural section dealing with the scrutiny of the NDF through Senedd. That does not include a soundness requirement, but it does include a duty upon the government to explain the reasons for what regard they have had to any suggestions made and coming through Senedd. Now, I think that to mount a court challenge based upon, say, for example, not applying an exceptional circumstances test to the creation or requirement of a new green belt, when the government is making new national policy, my hunch would be that the courts would be very reluctant to go there, because the government is given policy making powers and indeed duties under this legislation. And basically, the avenue of check and balance is Senedd. And so, subject to scrutinising the reasons, provided that they were not totally off the wall, I think that there would be little scope there realistically for review. With regard to the developments in national parks, the way that the modular reactor is described is being as a potential site, and it does defer to, it says subject to Planning Policy Wales principles, and PPW applies to, cross-refers to the statutory duties which apply to plan makers and decision takers in national parks, which are basically restrictive, and PPW sets out an exceptional circumstances test. So on that, it seems to me that in a sense there's all to play for through the medium of the forthcoming SDP for that part of Wales. If you will all forgive me, I'm now going to have to leave and hand you over to Craig, just to land the plane, as it were, of this webinar. But thank you so much, and happy Christmas and New Year to all. Goodbye.
Thank you very much, Morag. Very quickly, I'm sure everybody would appreciate if we had a finish at 4 o'clock as contemplated, but we're happy just to answer a few questions if we can. First of all, I'd like to draw attention to Barry Davies' comment in relation to resources for strategic development plans, and he, in short, has expressed concern, and it might help others to have a look at his comment, with which I've agreed. Mr. Chapman has asked, is it correct to say that the strategic development plans will mirror the proposed 4 economic development areas. At first blush, that seemed like a straightforward question. First, I should say that when I used the term mirror, I was only referring to the fact that the process is going to mirror that of the local development plan process. But your question, Mr. Chapman, is somewhat different and not entirely straightforward. Or to put it another way, I'm not convinced that the answer is accessible within a very short period of time. But it may help if I remind you that the purpose is for these corporate joint committees to be able to have strategic development plan powers akin to those that already exist. So I did look back to section 60D of the 2004 Act and noted that a strategic planning area must comprise all of the area of one local planning authority and all or part of the area of at least one other local planning authority. So that gives you one answer in the current statutory context. But what might eventuate from the current local government bill and the different regulations for different authority areas and different joint committees to be established may be different. And so I can only leave it there that at present, it looks like the intention is that the 4 constituent areas would perhaps form a basis for the strategic planning area, but I'm not sure that the committees won't have the power to choose a slightly different area, which might overlap boundaries and not include all of one area. Lastly, for my part, Mr. Adrian James, has asked whether strategic development plans will be assessed against the same tests of soundness. And I think the answer is, in part at least, at paragraph 4.17 of the consultation document from which I'll now read. The function of the examination of soundness is to assess whether the preparation requirements have been followed and whether the submitted LDP meets the test of soundness. The soundness tests are contained in table 37 of the Development Plan Manual and will remain relevant for an SDP, albeit they will be updated in the guidance produced in respect of the preparation of an SDP. So 3 unfortunate things to take from that paragraph. The first is there are 2 what appear to be typos. It should, in line 3, say SDP, not LDP. The table in the manual, I'm sure you know this, is table 27, I think, and I think I need to ask you to correct one of the slides. It should be table 27. And also you'll have noted that that table is intended to be updated. So it may well be that there are changes to the test for soundness insofar as they come within the scope of a document being updated. I now look to others, Charles and Annabel. We've got a little time. If you'd like to take any of the questions, I'd be very glad to ask you to do so.
Thanks, Craig. I've actually just commented on them in the Q&A box just now, the 2 that relate to compulsory purchase, and they're not really questions, but I'm grateful to Andrew Wood and John Davis for the additional information. So Andrew Wood, who is from the Welsh Government, who has updated us that the Cpo Manual will now be published in the spring and is currently being translated. So when I said end of the year, we're nearly there. So that's when that can be expected. And then John Davis has made the important point that in relation to the wellbeing goals in the circular, and I said that there's a section on this at paragraph 16 to 17, that it's helpful. Circular makes explicit that public bodies obviously must act in accordance with sustainable development, and they must, when making and justifying the compelling case for a CPO, give consideration to how the CPO achieves the 7 well-being goals. And it gives an example as to how they might interact in particular examples. For example, an empty dwelling, how that might be contribute towards a healthier Wales, for example. And also the Welsh ministers will need to give consideration to how their decision will also contribute to the wellbeing goals. So it's made expressly clear that they need to be taken into account and proved and justified in the process for the compelling case. So I think that's it really from me, but as ever, if anybody does think of anything else afterwards, then please do get in touch informally by email or any other means.
Good. Well, I think that that covers it. Charles, I think there weren't any questions. And that being the case, of course, it goes, as Annabel has said, you're very welcome to communicate with us and write to any one of us. We'd be glad to help as far as we can. But thank you very much for all of you for attending. I hope you found it informative and enjoyable. Diolch yn fawr.